So as engineers, the products of our work often have a profound impact on the safety of the public and health of the environment and lots of good things like that. So because of that, we're held to the highest standard of ethics and professional conduct. Our speaker today is David J. Evans, the Assistant Executive Director of the North Carolina Board of Examiners for Engineers and Surveyors, which you may know as NC-BELS. He joined the staff of NC-BELS in 1998. And as the board's assistant executive director, he supervises investigations of engineers, surveyors, and corporations, as well as non-licensed practice, which we're all licensed here, so don't worry. He also oversees business, licensure, and compliance, continuing professional competency, license applications and renewals, and the board's regular program of enforcement and education. David previously conducted criminal investigations in the U.S. Army as a military police investigator. He's a past chairman of the Committee on Law Enforcement for the National Council of Examiners for Engineering and Surveying and served on the Law Enforcement Advisory Group. He has a BA in History and Social Science from Eastern Connecticut State University, and we'd like to give him a warm welcome to the Eastern Branch.
All right. Well, thank you very much for having me. We've been doing a lot of these programs since the board started requiring you to get an hour of ethics and rules professional conduct every year. I think that requirement's been in place now for a few years. I will say it doesn't have to be a program that's put on by the board. It doesn't have to be specific to the rules professional conduct. It doesn't have to be engineering ethics. So you have some flexibility built into the rule. It can be more of a general ethics course. It doesn't have to be all the rules professional conduct. So you do have a little flexibility. And what I would say is if you are unsure whether the hour is going to count, certainly this is going to count. But if you're unsure in the future, you can always ask us, just shoot us an email and say, hey, this is what I'm thinking about claiming for the hour. Is this going to count? We have a staff member that does the audits for the board, and she should be able to answer it for you. And if not, we could always put it to the board's CPC committee. For those of you that don't know how the board works, we have 9 members that are appointed by the governor to 5-year terms, and they can serve a maximum of 2 terms. So we do have 2 board members that their terms expired at the end of December, Brenda Moore and John Logsdon. They will serve until Brenda is up for a reappointment. And I understand she is seeking it, and she's in all likelihood going to be reappointed. And then John Logsdon's in his 10th year, so he will not be reappointed. So we're awaiting a new surveying member appointment. So as a body, they get together usually about 7 times a year. And then they, of course, employ staff to do the day-to-day work for the board. And I'm a member of the board staff. Most of the work that the board does is through its committees. They have a standing engineering committee, survey committee, and a CPC committee. And then all of the board members also participate in the disciplinary committee process as well. I was mentioning earlier before we got started, one of the things that the board does is hear disciplinary cases. We don't have very many disciplinary cases, and they're open to the public. We actually had one yesterday. It ended around 6:30 or so last night, and it's a pretty interesting process to see. And as I was mentioning earlier, I actually felt a little sorry for the licensee that was before the board. But nonetheless, that licensee was entitled to the process that she went through, and I don't think it went quite her way. But yeah, so by statute, we have to have 4 engineers on the board, 3 surveyors, and 2 public members. Dennis Hoyle, who's here in the Raleigh area, he's a dual licensee, but he's one of our engineering board member appointments. And as I mentioned, the board does most of its work through its committees. And the engineering committee mostly responds to questions that licensees have or regulators have in the state. Questions about what constitutes the practice of engineering and different things of that nature. I guess it was maybe a year and a half ago, I was doing a program like this for DOT. And one of the questions was, what's the board's position on the use of AI? And I said, well, that's a good question because they don't have a position. So I asked him to put it in writing, and what I thought was going to be a pretty quick answer took about 18 months, but we finally gave him an answer, and now we have, I'm going to cover it here in a little bit, but we have guidelines on the use of AI in professional practice. So that's that kind of thing that our board will look at and answer for you, whether it's developing policy, developing guidelines, or just answering questions for you. Our board's been around since 1921. Its sole purpose is to regulate your profession as well as the surveying profession. I don't know if we have any surveyors in the room as well. We do have some dual licensees. At last I checked, maybe about 275 dual licensees or PEs and PLSs, and most of them have civil engineering backgrounds. And I understand everybody in here is probably licensed, so you've already kind of gone through the process, the application process. So that's kind of the first step the board does, is to vet applications to make sure that applicants are qualified to be licensed in the state. And of course, we verify the examinations, the fundamentals and principles and practice exams have been passed. We verify education, and then your progressive engineering experience. And for most applicants, it's 4 years of progressive engineering experience, depending on the degree, could be more. But that's what we're looking at. And then, of course, once you're licensed, you got to follow the rules, to include the rules of professional conduct, the certification requirements, the CPC requirements. Those are the 3 sections of the board rules that I really encourage licensees to be familiar with. Because if a licensee is going to get in trouble, I know everybody probably got the newsletter about a month and a half or so ago. I know everybody goes to the back to see if you know anybody, but look at what they're getting in trouble for. All of our actions are public record. I can tell you nobody wants to be in the newsletter, but if there's a disciplinary action, it's going in the newsletter. And then we also enforce the provisions of the Practice Act, and in North Carolina, the Practice Act is General Statute 89C. And I'm sure a lot of you are licensed in other jurisdictions as well. We have people that are licensed in, 30, 40, 50, there's more than 50 jurisdictions in the country, but we have licensees that are licensed in all of them. And the rules of professional conduct, certification requirements, CPC requirements, in North Carolina, we try to keep them pretty consistent with the national model. So hopefully those rules don't look too different from jurisdiction to jurisdiction. Same thing with the Practice Act. Every state has their little nuances, of course. But hopefully, the definition of the practice of engineering and the application requirements really don't look that different from state to state. The General Assembly gave the board the authority to regulate the professions so that the public is protected. And of course, you as licensees hopefully know that your primary obligation is to conduct your practice to protect the health, safety, and welfare of the public. I will tell you that some jurisdictions do have some authority over non-licensees. We're not one of them. So our authority extends to our licensees, and our fiscal year starts on December 1. So I ran the numbers just at the beginning of the fiscal year. We have a little over 41,000 licensees. Our licensed population tracks pretty closely to our overall population in the state relative to other states in the country. The vast majority of our licensees are engineers, of course. And last I checked, about 55% of our PEs are non-residents. So it's a pretty mobile profession. I'm sure some of you may be licensed in, half a dozen or more jurisdictions. Oh, excuse me. Is this not sharing to the?
It's sharing sharing your camera. No.
Do you not want that?
Can you share this?
I am sharing that.
Your presentation.
Can they see that now? Okay, sorry about that. Yep. On the surveying side, of course, it's much more of a local thing. About 75% of our licensed surveyors reside in the state. And then North Carolina is one of, I think, 5 jurisdictions that has a professional corporation act. So not every jurisdiction requires you get licensed with the engineering or surveying board. But we have about 5,000 companies that are licensed by the board. And I'd like to point out that, of course, all of you know that you're subject to the rules of professional conduct. and the other rules, but so are companies. So the board can and does sometimes pursue actions against companies for rules professional conduct violations. So I always like to point out that, while we have over 41,000 licensees, when it comes to discipline, we deal with a really small segment of our licensed population in any given year. Most licensees do the right thing every day, for the entirety of their 30, 40 plus year career. And their only interaction with the board is when they make application, they renew their license, maybe your continuing education gets audited once in a while, and that's it for your whole career. But we do, of course, have this mandate to regulate the professions, investigate complaints and the like. So last fiscal year, we had 164 cases total for the year. And there's a breakdown of the percentages of PE cases versus POS versus non-licensee. And I will tell you, over the last couple of years, we are seeing an uptick of non-licensee cases. In years past, typically it's about 20 to 22% is kind of about our average for dealing with non-licensees. And then, of course, we have some cases against licensed firms as well. The shocking thing to me are the what I kind of refer to them as our frequent flyers. Like I said, most licensees have no interaction with the board. However, 44 of the 164 respondents last year had 113 prior disciplinary cases. Not every case results in a discipline, I get that, but still 28 of them had 42 prior disciplinary actions. That blows me away. And it's like that every single year. That last year wasn't some fluke. It's like that every single year. So there are certainly certain names and certain companies I see, and I kind of cringe when I see their name come across my desk. That's not a good thing. So unless you've served on the board, I hopefully don't know your name. I've met a few people here today, but so that's not a good thing. But I will tell you that the surveyors tend to have a disproportionate number of the cases relative to their licensed population, and also a disproportionate number of the repeat offenders. And I think part of that is surveyors tend to deal more so with the general public than a lot of engineers do. A lot of engineers never deal with what I consider to be the general public, the homeowners and that kind of thing. Certainly, if you do engineering, you're dealing directly with homeowners, you're much more apt to have a complaint filed against you than if you're doing work just for government or industry and that kind of thing, because the public has no problem turning licensees in. So where do these cases come from? So last year, 40% of these came from what I consider to be the general public. And then certainly licensees file complaints. Any place that's reviewing your work, whether it's DOT or state construction, DEQ, local inspections, they're all a source of potential complaint if there's a problem with the work. Contractors. We have seen a little bit of an uptick of complaints coming from the insurance industry, to include public adjusters. And most of those complaints have to do with roof claims in the state. So a lot of times, as I'm sure a lot of you are aware, if there's an insurance claim for hail and wind damage, and the insurance company doesn't want to pay the claim, or they question the claim, they'll hire their own engineer to come out there and assess it. And what we're seeing is oftentimes the engineers, sometimes it's legit, sometimes they say, no, this is not a valid claim or what have you. And then of course, the property owners and the public adjusters disagree with it and are filing complaints against the engineers. They're trying to use the board essentially to kind of referee these things. And then, of course, the board can open cases on its own as well. So probably of most interest to this group is where are the engineering cases coming from? And less than half of them came from the general public. And then, of course, licensees, realtors, contractors, and the like. And we've gotten interesting complaints over the years. I've gotten complaints from ex-wives, former business partners, former employees, former employers. So the source can be pretty much anywhere. On the surveying side of things, typically it's about 80%, 85% of the cases every year are coming from the general public. Last year it was down a little bit, it was 64%. And then the surveyors are typically very reluctant to file complaints against other surveyors, because a lot of their work is on the public, on the public record in the Register of Deeds office, and especially in some of the smaller communities in the state, there might only be, half a dozen real active surveyors in a whole county. So they all follow behind each other and they all know each other, have made mistakes over the years. So they don't want to start that cycle of turning each other in. So like I said, surveyors are pretty reluctant to do that. On the other hand, licensees have no problem turning in non-licensees. So certainly that's been the source of a lot of the non-licensed cases. And then of course the board as well, some from the public as well. And this is a good segue into this next few slides, where I want to talk a little bit about the fraudulent use of the seal. Because I really want to raise awareness best we can with our licensees. We're seeing a real problem nationally about people committing fraud, stealing somebody else's license number, fabricating a seal, forging a signature, computer generated signature, and selling engineering services. Primarily it's engineering services. And the unsuspecting public is going on these freelancer websites like Upwork and Fiverr and those kind of things. And they're paying these folks who have created a fraudulent profile. And in most instances, the person committing the fraud is issuing a work product, and that's how they're getting paid. So the product's been issued, pay us our money. And it's being discovered mostly by reviewers in the state where they have questions about plan sets. And they're contacting the engineer, there's seals on the plan. And the engineer's like, I have no idea what you're talking about. That's not my project. And we had one instance in Charlotte not too long ago. There was actually some Chinese characters, text characters on the plan set. And it was kind of mixed there. So that was a little bit of a red flag for them. I just got a complaint on Tuesday, and the plans were drafted out of Pakistan. And it's actually on the plan set. So it's a little bit of a red flag as well. So it's a real problem, excuse me, nationally. And so of course the victim in all this is the public that's paying for these services that are not legitimate. And they'll file a complaint with the platform. They'll shut down the offending profile. They'll file a complaint with the board. Oftentimes it's the inspections department or the engineer is filing the complaint, say, hey, my seal's been fraudulently used. And in most cases, we're having trouble even locating these people, and they're not even in the country. So we have communicated with the Consumer Protection Division of the Attorney General's office to try to get some assistance to address this problem. And essentially where we've left it with them is every one of these complaints that we're getting, we're sending them to their office as well. Because quite frankly, the platforms need to do something to combat this, either verify that they're dealing with the actual licensee. There needs to be some more due diligence, I think, on the platform's part to verify the people that are providing professional services, because people are just getting ripped off. So it's a real problem. Like I said, this is a national issue as well. And I'll just add that one of the thoughts under consideration by our board and nationally is, do we need to rethink how licensees seal documents? Because let's face it, the old school computer generated seal and signature is not secure. I'm sure a lot of you use electronic certification where there's third-party authentication. Obviously, that's going to be more secure than the old school certification. But yeah, that's something that we're looking at, and that's something that's being looked at nationally about, and maybe your organization may be looking at that as well. I don't know, but it is a problem because the seals are just simply not secure otherwise. Okay, so let's shift gears a little bit, talk a little bit about ethics and rules of professional conduct. So when the board talks ethics, we're really talking about the rules of professional conduct. Obviously, as I mentioned earlier, hopefully everybody in here recognizes that your primary obligation as a licensed professional is conduct your practice to protect the public. That's your primary obligation. And obviously we have regulations so that the public has trust in what you do, that when they're driving on our highways or crossing our bridges or going into buildings or whatever, landing at our airports, that they know that the engineering that's gone into it is correct, that you've done your due diligence, that you're competent, you're qualified, all of these things. So it does give confidence to the public that the engineering is done correctly. And obviously, by doing the right thing and complying with the rules as a byproduct, hopefully you avoid any issues with the licensing board and legal issues, because obviously if you've done things wrong, then it opens you up civilly as well, and nobody wants that or needs that. And I'll add, and I mentioned the newsletter earlier, obviously you work hard to become a licensed professional, you build your reputation, and a disciplinary action obviously is going to have an impact on your professional reputation, right? If it's a public record, it could affect your ability to work. Some clients might not want to work with you or your firm. It could affect your ability to, somebody might not want to hire you with their company if you've got a disciplinary record. That could affect errors and omissions insurance rates if you got claims that are also, that resulted in discipline with the board. So there's lots of impacts that could have. So obviously, you want to do the right thing. So the way I kind of broke this down is the sections in the board rules are broken into sections. And for you as a licensed professional, these rules kind of set the framework for guiding your professional practice. There's other resources for you, of course. I know most of the professional societies, ASCE included, have codes of conduct that they expect their members to adhere to. NSPE's got them, IEEE, ASHRAE. There's, dozens of professional organizations. And a lot of the codes of conduct that, like ASCE, for example, would expect you to adhere to are pretty closely following the rules of professional conduct. And the rules of professional conduct really came out of the canons of ethics for engineers, which all of you probably got exposed to in college. And if you look at all the rules in the country, they're all going to pretty closely follow the canons of ethics for engineers. There's a couple nuanced differences, of course. But I always like to draw a distinction between the professional societies and the board, and that while I think an organization like this has an important role in public protection, you also are here to protect and promote your professions. And that's the big difference, because that's not why the board exists. The board only exists to make sure that the public is protected. Some of you may work for employers that have formal, ethics policies and that kind of thing. I know there are some employers in the state that have that. Most companies, though, it's about the culture. So what's the culture of a company? And I can tell you, I've been doing this a long time, and I've been involved in about 3,500 cases for the board. So I've kind of seen it all, heard it all. And there's certain firms that we've dealt with in the past that there's just not a good culture at the firm, and that trickles down to the employees. And obviously, if the leadership and the principals of the firm have, aren't doing things the right way, aren't complying with the rules, that kind of sets the stage for their staff to kind of follow suit. And we had a company a number of years ago that the board on its own opened a case against the company because we had so many complaints against their individual licensees, but more different licensees within the same firm, that we felt like, okay, there's a culture problem here. We got a problem with this company. Why are we seeing so many complaints against so many different licensees, that the board on its own opened a case against the company, and we pursued the company, and they were disciplined. So culture matters. So what you do as a licensed professional and leader in your company matters. The people that are working to become licensed professionals, they're paying attention to this. How do you conduct yourself when you're confronted with an ethical dilemma? Are you complying with the board rules? Do you take it seriously? They're obviously going to take take their cues from you as licensed professionals and leaders in your company. And then I will tell you that over the years, whether it's been criminal cases I've investigated or cases for the licensing board, when it comes to wrongdoing, most times the licensee or the subject, they know they're doing wrong, and they've justified it somehow to themselves or to others about why they did it. So a lot of it just comes down to just making the right decisions, choosing right over wrong. So obviously these rules exist to promote public trust. And as I mentioned earlier, these rules are subject to the businesses that you work for. So any consulting firm that's licensed with the board, they're all subject to these same requirements as well. And there's actually a rule within the rules that requires you to know the rules. So I've never known the board to actually charge anybody with that, but it is in there. You are charged with knowing these rules. And we do sometimes have licensees who will say, I didn't know that was a requirement, or I wasn't aware that rule changed. Well, you're obligated as a licensed professional to know the rules. And hopefully by the end of this session, you'll at least be pretty familiar with the rules of professional conduct. But like I said, be familiar with the CPC requirements and the certification requirements as well, because that's typically what licensees are getting in trouble for. This next section basically requires you to conduct practice to protect the health, safety, and welfare of the public. This is the most frequently cited provision against when we charge an engineer with wrongdoing, Board Rule 701B. And this covers when we get a complaint about deficient design documents, substandard reports, substandard specifications. If we get those kind of complaints about work product, this is what the licensee is charged with. Hey, you didn't conduct your practice to protect the public, and here's all the alleged deficiencies. There's also a provision in this section that requires you to take action if your professional judgment's overruled and the public is endangered. You can't just say, okay, you're my boss, or okay, this is what the client wants. No, if the public's endangered, you have a professional obligation to notify the appropriate parties. That could be including filing a complaint with the board. It could be notifying the regulators, notifying the client, notifying the employer, whatever. You can't just turn a blind eye, just accept it as is. You have to speak up. North Carolina, like most of the states, license you as a professional engineer, and the caveat, meaning we're not a discipline-specific state. There are some states that require you to declare your area of practice. I think Oklahoma, is there anybody licensed in Oklahoma here? I think Oklahoma makes you declare an area when you apply. There's certainly some structural states that have require you to have the SE designation to do certain types of structural work. We're not one of them. But in North Carolina, you have to practice within your area of competence. So that's where you have to make the determination as a professional, where's the line? What is my area of competence? So obviously that changes throughout your career. And typically when we interview licensees, we ask, area of competence. And, very rarely does somebody say, well, I'm a structural engineer, and to leave it at that. They usually qualify what kind of structural engineering they do. Or civil, they don't just say civil. There's, of course, lots of different aspects, as you know, in civil engineering. So they qualify what their areas are. And even within a discipline, you may have, hopefully you have a line. For example, somebody might be competent to, do foundation work and maybe size beams and that kind of thing, but they're not doing the structure on a 40-story building. So, in fact, most of the folks that take the structural exam from North Carolina are already licensed as PEs, and they take the exam because they want to practice in a jurisdiction that requires the SE designation. And kind of along those lines, when you're pursuing work, you should only be pursuing work that you're competent and qualified to do. And of course, if you are taking on projects that include disciplines outside your specific area or your company's area of expertise and competence, then that work needs to be subcontracted or done by other licensed professionals that are competent in those areas. I will tell you that the board can and has in years past restricted licensees' practice. We have that authority to do that as a result of disciplinary cases. So when we've done that, it's typically a restricted to a particular area or from certain areas until such time as they take the NCAAS exams, the principles of practice exams, and any other discipline. The board can impose education as part of discipline, and of course, we can require reexamination altogether. I want to talk a little bit about responsible charge. Hopefully everybody remembers getting an email from the board. I guess it's been about maybe going on 2 years ago now. We sent it by constant contact. We don't send too many emails to you. We let you know, hey, it's time to renew. And then if there's something substantial we want to let licensees know, we send a constant contact email. So when the board changed the rule with respect to responsible charge, we felt like, hey, this is a big enough change. We want all our licensees to know this has been changed. So of course, everybody here is familiar with NCAAS because you took the examinations. But what you might not know is NCAAS is actually made up of the licensing boards in the country. That's what makes up that body. They, of course, employ their own staff in Greenville, South Carolina. They have, folks that help them with examinations and whatnot. But the licensing boards in the state make up that organization. And the organization does more than just write the fundamentals exam, the principles and practice exams, and administer them. It also develops model law and model rules. They have committees that work on these items. And like I said, North Carolina, we try to stay pretty closely aligned with the national model. So when the board talked about changing the responsible charge rule, again, they studied this for probably 3 years before they actually made the change. And what they ended up doing was adopting the language from the national model. So just like the 1 hour ethics and rules professional conduct requirement that you're getting now, we took the language right out of the national model. So that is part of the national model. So this isn't the exact language. I kind of paraphrased it here. So one of the big changes was prior to this change, you could only sign and seal work that you personally prepared or was prepared under your direct supervision by an employee. So the board took the word employee out when they made the change. So it opened it up a little bit, gives licensees a little more flexibility about who you can exercise direct supervision over. However, the board goes on to define the rule in much greater detail than the old rule. So some of you may have remembered getting newsletters in the past where the board would talk about attributes of responsible charge. So the board was trying to educate licensees about, hey, this is what responsible charge should look like. If you're kind of meeting these attributes, then that meets the test. You're going to be in compliance with the rule. But essentially what the rule does now is it takes those attributes and it codifies it in the North Carolina Administrative Code. So now it is part of the rule. So I think it does a good job of better defining what it means to be in responsible charge instead of you having to go back and look at some old newsletter to say, well, this is really what the board means by this. So although you can supervise somebody who's not an employee, you still have to be in full control over all the work. You got to have full professional knowledge over the work. And this is not a case where some non-licensee, non-employee's done some engineering and then's bringing it to you for review and certification. That's not responsible charge. You're not directing how the work's been done. You weren't privy to the parameters, the limitations, all the project requirements, because you're brought in after the fact. That's not responsible charge. That said, though, I will say that there are going to be times, and some of you probably have experienced this before, where maybe somebody within your own firm has done something. Maybe they're 90% of the way done with something and they passed away or they've left your employment. And now it's brought to you, need you to finish this project, and you had nothing to do with it. Well, guess what? You need to make it your work product. So you have to go kind of above and beyond to document what you've done to make that your work product. So if you got to run all the calculations over again because you weren't a party to it the first time, then that's what you got to do. So whatever you got to do to make it your work product, because it's no longer going to be that first licensee's work. It's now going to become your work once you sign and seal it. It's actually in the rule that you need to be capable of answering questions about the work you sign and seal. I know that seems kind of fundamental, right? It's in the rule. And you'd be shocked to know that I've actually been in interviews before with licensees, and they know we're coming. They know what project we're coming to talk to them about. And they know what the alleged issues are, and they still can't answer the questions. They got to bring in employees to answer questions about work they signed and sealed. That's not a good look for responsible charge. So it's actually in the rule now that if you sign and seal something, you better be able to answer all the questions that pertain to that. And obviously at the end of the day, even if you had half a dozen people working on it for you, which is permitted, you accept full responsibility for it, you own it. So I can tell you pointing fingers at employees isn't a good look for the board either, because that's a you problem. If you sign and seal it and you didn't have adequate processes in place for QA, QC or whatever, that's on you as the licensed professional to make sure that you have all these controls. And obviously the level of supervision that you exercise comes down to your professional judgment, right? So if you've hired somebody that just graduated from state and they've worked for you for 2 months, well, that person's going to require much greater supervision than somebody that's been with you for 15 years. But still, you're responsible to determine where that line is. The rule actually goes on to say that you're responsible to have records to support what you've done on this project. So we do sometimes get questions from licensees about how long do I have to keep my records? There's nothing in the statute or the rules that say, hey, you got to keep it for 5 years, 7 years, 10 years, or whatever. So we tell licensees, check with your errors and omissions insurance carrier, get their take on it, or check with your own corporate counsel. Or if you work for state government, obviously some records retention policy, laws are going to apply and the like. But yeah, the burden's on you to have records to support what you've done. And that's important because it does go to show if you had any involvement or what your level of involvement was and that kind of thing. And I can tell you that I've done an interview before with a licensee on a church case, and he was coming to the board office for the interview, and obviously he knew we were investigating him. And the night before, I called him and said, "Hey, bring your project file." He had 2 pieces of paper, yellow line paper, with some things scratched out on it. So he didn't have enough time to create a project file, and that was it. So that's not a good indicator of him being in responsible charge. There's also you're also permitted to certify work if it has it's the work of more than one design professional, more than one professional. That's permitted, provided each licensee denotes under the seal what each is taking responsibility for. So if you both had input in an engineering report, you can both sign and seal it. Just delineate what each is taking responsibility for. Same thing with a plan set. We do see that every once in a while. One engineer's done one part of it, another engineer's done another part. That's okay. You just need to denote. So if the board's looking at it or the reviewer's looking at it, that they know if they got questions about something, which engineer to contact. We also have provisions in the rules that require you to be truthful and objective, to include all relevant and pertinent information in all your professional statements, whether that's in engineering reports, testifying, being deposed, anything that's your professional work product. It's got to be truthful. It's got to be objective. As I was talking to some folks earlier, we had a hearing yesterday before the board against a licensee from Texas. She came here from Texas, and one of the allegations was she was not objective and truthful and didn't include all relevant and pertinent information in a design professional inspection form. And she was found to be in violation. But so that is required. Some of you may testify in court cases. Some licensees do this for a living. And other times you have no choice because project went bad or whatever, and everybody gets sued and everybody gets deposed. But nonetheless, if you're testifying as to engineering matters, you got to be truthful, got to be objective. And if you're rendering engineering opinions for these cases, it's got to be based upon adequate knowledge of the facts at hand. We also have provisions that if you're making statements, engineering statements regarding public policy, of course, everybody's entitled to their, makes their statements and whatnot. But if you're being paid to do it, then you need to disclose that you're being paid to do that. We also have rules that prohibit you from indiscriminately criticizing another licensed professional. So don't badmouth other licensees, don't badmouth other firms. What I will say is that there's certainly times where licensees are hired for the very purpose of criticizing another licensee's work. That's okay. Provided it's truthful, it's objective, you've got valid basis for the criticism, you've included all relevant and pertinent information. A client can hire another engineering firm to critique somebody's work. That's okay. If there's, if that's what they so choose. But if you really have a problem with another licensee's work, rather than indiscriminately criticizing it, and it's an issue for the board, file a complaint with the board, let the board deal with it. I'll also add that we do have within the rules of professional conduct, rules of conduct of advertising. And essentially what they say is, and we don't see too many engineering firms advertising per se, but a website's a form of advertising. I know a lot of firms have marketing materials. That's a form of advertising. And the rule says you can't make exaggerated, misleading, deceptive, or false statements. I like to keep it simple. Don't lie. If you don't lie, we don't use that word in the board rules, but if you don't lie, you're never going to have a problem with the board as far as how you're representing your qualifications or your past accomplishments and that kind of thing. Uh-oh, that's not good. There we go. We do have conflict of interest provisions in the board rules that you should be familiar with. In general, licensees should try to avoid conflicts of interest. However, there are times where you might have a conflict of interest that comes up. And when that happens, and sometimes we get questions from licensees, something like, hey, I'm a part owner of a development company, but I'm also doing the site work, the engineering site work on this project. Is that permitted? Well, clearly there's a conflict of interest there, right? So in a case like that, disclosure is important. You need to let the reviewing agencies and anybody else that needs to know that, hey, I also have this other interest in this project. Sometimes we see it on the surveying side where, surveyor may be wanting to survey their own tract of land. Is that permitted? Well, clearly there's a conflict there. So they need to let the reviewers know for sure and the adjoiners know, hey, this is being done. And when we get these questions from licensees, we don't get too many complaints about this, but we get a lot of questions from licensees about it. And when we do, we always encourage licensees, put your disclosure in writing. So if it's questioned 6 months down the road, you can pull out your email or pull out your letter and say, no, I let the reviewers know down at DEQ I had this, potential conflict or whatever. So put it in writing. There is one provision in the board rules that requires licensees to get it in writing, and that's if you're being paid for more than one party for services on the same project. We don't see this too often in the engineering world, but we do see it sometimes on the surveying side of things where, surveying company might be surveying a tract of land and they're approached by joiners. Hey, that while you're out here, can you also survey my tract? You've already surveyed, 3 of my lines. They're thinking it's a cost savings. So clearly there's a conflict there because you're serving one client and so in those cases, that licensee has to get agreement from both parties that they're okay with that. And if they do, then that's fine. They can do that. And then I call the last ones here kind of the kickback provisions. Some of these seem pretty apparent, I think, that obviously you shouldn't be getting some kind of remuneration or kickback for specifying certain material suppliers or equipment suppliers and that kind of thing. And then also, if you happen to be in public service, again, this seems fairly obvious, but you should not be sitting in consideration for services that you or your firm are providing to that public agency. And I always like to give examples just to put things in perspective. And like I said, I've kind of seen a little bit of everything over the years. And probably the worst case of this we had actually involved a non-licensee that had a partial ownership interest in an engineering firm. So under the Professional Corporation Act, up to a third of a company can be owned by non-licensees. So in this case, the non-licensee worked for a state agency and was actually one of the reviewers grading firms to decide who was going to be awarded contracts, to include his own firm, and didn't recuse himself. So in a case like that, since we have no authority over the non-licensee, we went after the company that he had an ownership interest in because we do have authority over the company. So that's an example of that. And we have had a few examples over the years where if you're a principal or an officer of a company and you also serve on a governmental body that's awarding a contract, your firm can't go after that work. Whether you've recused yourself or not, you can't go after that work. So put yourself in the competitor's shoes. And if you're the county commissioner and that county's awarding all the work to your firm, that's a problem. And we have had, like I said, several examples of this over the years. And then last one is about supplanting. We don't get very many complaints about supplanting, but we do get questions about it from time to time. This is where if a licensee or a firm's been awarded a project, another licensed firm or licensee can't go behind their back to try to steal that project from them. It's theirs. So sometimes we know clients want to terminate their services with a firm and go with another firm. So a lot of times what they do before they terminate services is they start shopping around. Are you willing to finish this project? Can you give us a proposal to take over and all this? What we would caution you is you might want to make sure there's a clean break with that first firm before you start making an offer to provide services on a project so you don't get accused of attempting to supplant that other firm. So that would be our best advice. And then, of course, as I think I touched on it earlier, when you're pursuing work, it needs to be on the basis of your qualifications, your firm's qualifications, and your licensee's competence to do the work. You should not be paying a commission to secure a professional services contract. We have seen this a few times on with surveying projects. before. I can't think right off of where we've seen it on the engineering side of things, but basically, you shouldn't be paying somebody a commission for a professional contract. And then I kind of touched on this earlier. Obviously, don't misrepresent your qualifications and your ability to do a particular project. I will tell you, it's probably been, I'm going to think 25 years ago now, the board added a rule that basically said that as a licensee, you can't knowingly cooperate in a violation of the Mini Brooks Act or the Brooks Act. That's QBS for state municipal work or federal work. And prior to the board adding this provision in the rules, our board really didn't get mixed up too much in QBS complaints. We just didn't see them that often. But after we implemented the rule, we got a lot of complaints. And I think over the years, companies and individuals have gotten much better educated about QBS and Mini Brooks and the Brooks Act. So if you do a lot of this kind of work, you all probably know, what it's supposed to look like when you get a request for qualifications. And the municipalities and the state agencies have gotten much better about it. There were a few kind of notorious municipalities that were not complying with the intent of the law. They had cute ways to basically arrive at total cost anyway, but they did it under the guise of they were complying with the law, but they were not. So we do have this provision in the rule that says you have to comply with the QBS requirements. There's certainly, if you do a lot of this kind of work, be familiar with the requirements and the exemptions. There are some exemptions that municipalities and DOT can ask for fees at that point, but it should be known at the outset if it's been an exempt project. And if you do a lot of this kind of work, we do have some more information on our website under the policies and guidelines section of the webpage. Our attorney, his name's Wes Tripp, he put together, so it's a good resource for you. And then we have kind of these general provisions that require you as a licensee to perform services in an ethical manner and a lawful manner. So the rule doesn't define what ethical means, so the board gets to define what that means. So if there's not a specific provision that covers the alleged wrongdoing and the licensee is charged with this, the board's going to get to decide whether you were ethical or not. We also have provisions that prohibit you from associating with non-licensees. These are people that are basically practicing without a license or with associating with companies or individuals that are committing some kind of fraud. And we have had certainly this before. It's also against the law to aid and abet non-licensed practice. So we've had a number of cases over the years where non-licensed firms, they don't have the wherewithal to be licensed in the state. They don't have licensees that work for them. So they find a licensee that's willing to sign and seal their work. That's aiding and abetting non-licensed practice. So not only are we going to go after the company or the individual, but we're also going to go after the licensee who without, they couldn't do what they're doing because they need your seal. And I can tell you in those kind of cases, they're not looking out for your benefit. And a lot of times these licensees have sold their seal cheap. So they're not even making any real money doing it. And it's never ends well for the licensee. I will tell you that we have a rule that requires you as a licensed professional to file a complaint if you're aware of a rule violation or a statute violation. What I would tell you in this setting is use some judgment. So if the public's truly endangered, don't turn a blind eye. You have a professional obligation to do something about it. Say something about it, file a complaint. Most times people that are going to file complaints will contact us first and they kind of want to talk it through. And, obviously if you talk it through with me or one of my investigators or our board attorney, we're not going to say, yes, this is absolutely a violation, file a complaint. That's not my job to determine. That's up to the board to determine. But what I will tell you is this needs to be investigated. The board would want to investigate this. And we'll tell you what we would need from you in order to pursue that. But of course, as licensees, you have to accept correspondence from the board. So if you get some certified mail from the board, don't dodge it because the rules require you to accept correspondence from the board. There's also a rule that requires licensees to report any discipline or criminal convictions within 30 days. So we get a lot of these at renewal time. It's also asked at renewal time. So we look at a lot of these. I will tell you that we just changed our rules. So licensees only need to report revocations, suspensions, restriction of practice, or refusal to renew a license as a result of discipline. It used to be all discipline had to be reported. And like I said, we've got folks that are licensed in 30, 40 jurisdictions. So all the jurisdictions have this reporting requirement. So they got to report it to all the jurisdictions. So all we really cared about in the past, and as a practical matter, is if a licensee's lost their ability to practice, then we don't want them practicing here. So that's really all we care about. So if Alabama issued somebody a reprimand, there was a reprimand case, and Alabama took care of it. I will tell you that most of the jurisdictions in the country will pile on discipline. So I've always thought that was fundamentally unfair to licensees. Unless it's a loss of a license or a restriction, then okay, if you're not fit to practice in Virginia, then we don't want you practicing here. So, but there's states where if, we would issue a reprimand and a $5,000 civil penalty, and they're licensed in 20 states, and 10 of them pile on the civil penalty, that gets to be very costly for the licensee. And it's not really fair, in my opinion. So that's why our board changed the rule. And now we only care about if somebody's lost their ability to practice, and then we'll likely do the same thing. I will tell you that all of our investigations are confidential. So, if a licensee or even a non-licensee gets a letter from the board saying, hey, we're investigating you, it's for this project, here's the alleged issues, we're not going to give them a copy of the complaint. We're not going to tell them who filed the complaint, but they can generally figure out where it came from because they've probably already known, okay, this has been through 3 rounds of reviews with DEQ, and they've had, 3 pages of review comments every time. And that's probably where it's coming from. But we're not going to tell you at that point who filed the complaint because it's confidential. There's also a provision in our statute that requires licensees to cooperate with investigations. I will tell you, there's no quicker way for somebody to lose a license than to not cooperate. And we have certainly, I'm pretty much the board's going to take a license if they're not cooperative. If they're not responding to the case opening letter, they're not consenting to an interview, they're not answering our questions, they're going to lose their license. Even if the underlying issues weren't a revocation offense, if they don't cooperate, they're going to take it, because what's that telling? That's telling the board that they're not subjecting themselves to the board's authority. And if we don't have authority over the licensees, then we can't regulate you. So make sure if you ever, God forbid, end up having to talk to the board about anything, cooperate. And we've had out-of-state licensees think that, well, I don't really do much work in North Carolina, I'm just going to ignore it. And then they get revoked, and then their home jurisdiction revokes their license as well. So they need to think about that. I will tell you that at any given time, we have a case on appeal in the state court system. So I will tell you, if you read something in the newsletter, licensees get their due process. The General Assembly gives the board certain authority. We operate within that authority. The rules kind of lay out what we can do, how we do it, and all this. Licensees get their due process. And the General Assembly says, here's what you can do when somebody's found to be in violation, and that's what we operate within. So yesterday, as I said, we had a hearing before the board, and it was a loss of license case for a period of time, civil penalty, additional education, the whole 9 yards. And that's likely to get appealed into Superior Court. So Superior Court's going to review the case on basically on the record. They're not going to relitigate it. The board's already heard the case. And since I've been with the board's batting 1,000. We've never lost a case. So that should give you a lot of confidence that licensees get their due process. And it's very expensive, by the way, for the licensee and for the board to fight these cases. But yeah, so if Superior Court, then it goes State Court of Appeals Court, and then State Supreme Court. So, if we have to defend an action of the board, we'll certainly defend the action and spend the money. And, licensees do that as well. So it's very expensive, but the board has an excellent track record. What I will add is in North Carolina for administrative law, the standard of proof is the preponderance of evidence. That's a super low legal standard. All that means is it more likely than not that somebody committed the violation. It's not like criminal case where it's beyond a reasonable doubt, much higher legal standard. In my experience, though, and I've worked with lots of board members, the board applies a higher standard than is it more likely than not. So if you read about somebody in the newsletter, the board had the evidence to support the case. I know everybody goes to the website at least once a year to renew your license. The board tries to basically put everything out that a licensee might need as a resource: policies, guidelines, the law, the statute, the Professional Corporation Act, board rules, newsletters, meeting minutes, whatever you might need to know about the board. Probably find it on the website. If you can't, call us, use us as a resource. Y'all pay a $75 renewal fee every year, get something for your money. We don't charge agencies to come out and do these programs for your PDH. But yeah, use the board as a resource. As I mentioned earlier, the board did adopt some AI guidelines in the use of professional practice. And the guidelines can be found on the website. This is kind of highlighting them. And a lot of these guidelines really go back to responsible charge and competency. That's kind of the guidelines keep drawing back on. You got to be still in responsible charge and you got to be competent. You can't use AI to develop some new area of competence. That's not how that's going to work. But you gotta have some protocols in place to validate whatever models you're using or what have you. And we went out and talked to stakeholders that are using this technology in their practices now. A lot of it's being used for proposals and whatnot. Yeah, and it can be used as a great starting point, but you're still responsible for all the information that's gone out. If your seal's on it, you own it. And you can't say, well, the model produced hallucination or bad info or whatever. You're responsible for it. So you have to be involved in it. You have to supervise the work just like you would an employee. Obviously, you got to be able to answer questions for it. You can't say, well, that's the answer it gave me. That's not going to work. And you got to have records to support what you've done, just like with any responsible charge matter. You need to understand the data. You got to be able to replicate it, and it's got to be validated. I talked a little bit about competency. Obviously, this is, I don't know, show of hands, is anybody here using this technology now in their practice? Yeah, a few people. So it is being used for sure. But it's changing very rapidly. So keep up with the technologies and the models and so forth. Let's see. Obviously, you can use, the board kind of looked, so when I first got asked the question about a year and a half ago, in my mind, I'm thinking, okay, this is just a tool, just another tool in your toolbox to do your job, right? So I was thinking of a real simplistic view of it. And when the board kind of looked at everything, that's kind of what it is. It's a tool. It can enhance your work, but it doesn't replace your professional judgments. You're still fully responsible for all of this. And then, kind of the last takeaway is, if you adhere to the guidelines, this is going to, you shouldn't have a problem with the board, basically, is what it's saying. I will tell you the National Council has also got a position statement on this. It aligns pretty closely with where our board ended up with the guidelines. I will tell you that AI has been used to create fraudulent engineering documents. Some of these freelancer websites, these folks are using this technology to develop a professional work product, and that's what they've been issued to get paid with one of your seals on it. And as I already talked about, seal security is going to be a big part of going forward to try to combat this. These last couple slides, I will tell you, we had a licensee. He was been in trouble a few times with the board, I think 5 times total before he finally lost his license. But one of the disciplinary actions, the board got a little creative with him and said, hey, as part of your disciplinary action, you need to come back before the board at a future meeting and make a presentation about all the lessons you've learned on these last 4 cases. And so he had to present it to the staff first before we would let him come before the board. And he put together this big PowerPoint presentation, and a couple of the slides I liked. And I asked if I could use them for our programs. He said, yeah, go ahead. He never actually got to make the presentation before the board because he had another complaint filed against him before he could come in, and we ended up taking his license. But I still like some of his bullet comments. So he says, know what you do well and stick to that line of work, we're talking about competency. So solidify work with a written agreement. There's nothing in the board rules that say you have to have a written contract or scope of services, but it can really go a long way. And I know some firms don't touch anything without a written agreement. It really can go a long way to make sure that both parties are on the same page about the services being provided. Make sure you're dealing with reputable clients. And, we've certainly had more than our fair share of shady contractors out there doing things than looking to their engineering buddy to sign off on stuff. They're not looking out for you, that I can assure you. Keep up with board rules and interpretations, review the disciplinary cases in the newsletter, use peer reviews. And I think what his point was, in this case, this engineer, former engineer, he owned a small engineering firm. He did mostly residential work, and he was the only licensee. And he kind of operated in a bit of a vacuum. He'd been operating his own company for a number of years and really didn't have good mentorship coming up in the profession. In fact, one of his mentors growing up in the profession had also been revoked. So he didn't really have a good mentor, and he wasn't real active in professional organizations. And I do programs like this at State, and we do them for Duke and UNC Charlotte for the students. And I always encourage them, hey, get involved with the professional societies. For one, it's a good way to network with employers, but potential employers. But also you get some mentorship that you might not get depending on where you go to work. So he recognized that, okay, maybe I needed just be able to bounce something off people, just being able to network with people. Hey, this is what I'm looking at. But also you can use the board as a resource as well. He also felt it was important to be wary of getting involved in projects that were in litigation. Sometimes that's beyond your control. But I think he was really referring to, the engineers that testify for a living, if you will. Slow down. Doesn't feel right, don't do it. And if you remember anything from this spiel, if you got questions about stuff, call us, email us, send it to us. We'll look at it. We can, take a look at the rule. We can look at the statute for you and kind of give you some guidance on it. A lot of you may have dealt with David Tuttle over the years. He was our longtime board counsel, probably 30 years. He retired a few years back, and his replacement's name is Wes Tribb. He's a really good resource for you as a licensee. We're not going to provide you your company legal advice. Your corporate counsel needs to do that. But when it comes to interpretations of the statute and the rules, filing complaints, mini Brooks, this kind of things, use us. That's what we're there for. That's what you pay a renewal fee for. I put my email address up there. If you got any questions you don't want to ask in front of the group, or if you want to email Wes, Wes is probably a better resource for QBS questions, I would say, than I am. I could probably answer some of these questions too, but he's a little more versed in that than I am. So with that, I'll, I guess, open it up to talk about anything I covered or anything else. If I can answer it, I will. If not, I'll try to get you an answer. Yes, sir.
You're talking about AI tools. Does the board itself use AI for anything?
Very limited. So we're looking at it though, and how that could be used. And I'll also tell you, NCAAS is looking at it. I went to a annual meeting back in New Orleans a few months back, and their IT manager did a presentation on how they're looking at using it, and they're in the kind of the beta test phase right now. So they actually, and by the way, most people that apply to get licensed in North Carolina are using the NCAAS records program. And we encourage applicants to use it because it makes comedy so much easier. So if you want to get licensed in 10 other states, that's so much easier to have an NCAAS record. So I'd say probably 95% of our applicants are using that record now. So they employ folks to do experience reviews. And I was actually shocked at the rejection rate that they have. These are engineers that are doing the reviews, that it's not either engineering or it's not progressive in nature. So for whatever reason, they have a pretty high rejection rates. I want to say it was like 40%. It was pretty high. And so their NCAAS is paying these reviewers. It's very time consuming, and they're doing this for thousands of record holders. So they're actually developing a program, a model that can review experience as kind of the first blush for the applicant and give the feedback as to whether it's going to work or not. So obviously, you know, the board's ultimately responsible and a human's ultimately responsible. We can't rely on a model to approve, you know, an applicant, but it can be used as a tool. So that's how they envision possibly using it. Was there another question over here? Yes, sir.
Has to do with PDHs.
Okay.
So if you're preparing a presentation such as this,
Mhm.
you get 2 credits of PDHs to that plus the actual presentation.
So if you're the presenter and it's a 1 hour program, you can claim 2 hours. First time you present it. So I'm not a PE, but if I was, and I did 50 of these last year, I can't claim 100 PDHs. So yeah, so the first time, unless you make substantial updates to it in the subsequent years, then you can claim the credit again. Yep. Yes, sir.
It may have been clarified since the last time I looked, but is the 1 hour of ethics part of the 15 hours?
Yeah.
Or is it extra?
No, it's part of the 15. Yep.
And if you have accidentally 2 hours of ethics in 1 year, would both count toward the 15?
Yes. So you could have all 15 hours could be ethics. So if you took, like, Texas Tech has a online ethics course, one of the, I think the shortest one's 30 hours. So that would be your CPC. And if you have carryover out, let's say you had 2 ethics hours last year and you had 16 PDHs total, you could use one of those carryover hours for this year. So
Part of that then, do any of the, if you had an extraordinary number of hours in 1 year for some reason, does it only carry over to the following year?
Yes, sir, that's correct. And it's a maximum of 15 hours carryover. Yep. And oh, by the way, we're one of the few states that has annual renewal. So most states are every 2 years. And we are looking to change our statute and rules to do an every other year renewal. I think that's probably going to roll out in the next probably 24 months. So the CPC rules will also have to change to kind of keep up with that, but that is probably something that's going to be happening. Yes, sir.
So, recently, we'll talk with everything going to 3D modeling of sealing the model.
Mhm.
Has that come up?
Yeah, we have some guidelines on the board's website that talk about that. And then for the last probably, I'm gonna say 2 years, the board's had an ad hoc committee looking at electronic certification requirements, and as an offshoot of that, the 3D model as well. So that is certainly something that's actively being looked at by the board.
Yeah, and what's the latest on the electronic seal certification?
So we've had our rules in place in Board Rule 1103, the third-party authentication. That rule really has remained unchanged for probably 20 plus years. And I think it's served us pretty well. And we kind of put the onus back on the licensee that there's different software packages you can, of course, get, but you need to make sure that if whatever you're using satisfies those basic requirements. And I still remember at the time when the board was looking at that rule, adopting that rule, they're like, oh, we're never going to be able to keep up with the technology. Let's just say what it is we want it to do, and then put the onus on the licensee to make sure that they're getting the right software to do that. And we've seen issues with like the self-certification, and there's lesser versions of things where do you trust this source? That's not third-party authentication software. So we have had some confusion on that over the years, but obviously anytime the board makes changes like that, we'll project that information out through newsletters and public comment and the like.
So if it's the board's position, it's in your guidelines, so the legislature then has to, because I heard there was a disagreement between the board and the state legislature as to what a satisfactory seal was. Has that been resolved now?
So the board rules dictate what the certification are under Board Rule 1103. The General Assembly gives the board the authority to develop these rules, and
About a year and a half, maybe 2 years.
yeah, anytime we do a rule change, we have to go through a rulemaking process, and it has to go through Rules Review Commission. And essentially what they're looking for when they do that is, the I's dotted, T's crossed, but they're also looking primarily is, does the board have authority to even make this change by statute? And if we don't, they're not going to approve it at Rules Review. So that's kind of what that,
been resolved.
as far as I know, yeah, I don't, yeah. All right, well, thank you for having me.